Case challenging former President Trump's eligibility to be on the 2024 ballot here in Minnesota was before the court today.
Yeah, the case was heard this morning inside the Supreme Court. Chief political reporter John Croman joins us now with what happened.
You know, both sides agree the state has jurisdiction on basic qualifications to be president. Are you 35 yet? Were you born in this country? You're sure you haven't already served 2 terms? But where they differ is whether someone can be bounced from the ballot over a specific incident, in this case, January 6th.
Donald Trump engaged in rebellion and insurrection against the Constitution of the United States in a desperate attempt to remain in office after losing the election.
Ronald Fine represents the plaintiffs trying to keep former President Trump's name off the 2024 ballots in Minnesota, asserting that Section 3 of the 14th Amendment automatically disqualifies anyone who took part in a rebellion against the Constitution, in this case, January 6th.
Let's say we agree with you that Section 3 is self-executing and that we do have the authority under the relevant statute to keep Mr. Trump's name off the ballot. Should we?
204B44 provides no discretion for the court to decline, and in particular it says that the court shall decide the facts and order a hearing.
Trump attorney Nicholas Nelson says qualifications should not be decided by the courts.
All this line of authority reflects an important reality about the purpose of the political question doctrine, which is to ensure that, obviously, political questions and judicial questions remain separate.
Nelson also argued what happened January 6th was not an insurrection.
What happened on January 6th was crimes, some of them serious, was violence, some of it serious, but that it did not reach the scale or scope of what would be regarded as an insurrection.
One of the plaintiffs in the case is former Secretary of State Joan Grow.
I've always been interested in democracy. I always wanted people to participate. And this seemed like a way to have a better government, a better participation.
Now, the first thing the Supreme Court needs to decide is whether or not to hold an evidentiary hearing. That would involve taking testimony on whether January 6th was an insurrection and whether the former president's role in that incident was sufficient to trigger disqualification laid out in the 14th Amendment. They're expected to move quickly because early voting in the March presidential primary starts January 19th, and you know this will probably be appealed to the U.S. Supreme Court. Back to you.